Oh, now call 124-174 State of Kansas versus Deante Jones.
Good morning, and may it please the court. Hi, man of the Appellate Defender's Office on behalf of Mr. Jones. Started. In an earlier self-defense case, this court observed that the existence and the proper exercise of power are discrete concepts. This case rests at the intersection of those concepts. Due to the immunity error, the power employed by the district court to accept Mr. Jones's plea and impose his sentence was illegitimately gained and exercised. I make it clear that I'm not accusing the court of ruling in bad faith or judicial tyranny stemming out of Hutchinson, far from it, far from it. But what I am arguing in this case is that because proper self-defense immunity findings, when necessary, are required for a district court to access its general jurisdiction to handle any other aspect of a case, error in making those findings deprives the district court's jurisdiction, making its subsequent actions void. So therefore, this case is centered on two claims. I'm sorry, I'm a little bit congested. First, that the district court erred as a matter of law, in fact, in assessing Mr. Jones's self-immunity claim and below. And secondly, and I think that's where we're going to focus here today, is that those errors deprive the district court the subject matter jurisdiction necessary to accept a plea from Mr. Jones. Stated another way, the immunity determination of KSA 215231 is jurisdictional in nature. And there are a few reasons why. First, we need to start with the concept of subject matter jurisdiction. Kansas statute provides that subject matter jurisdiction of a district court exists in two categories, civil and criminal. The entirety of a district court's subject matter jurisdiction falls into one of those two camps. The Constitution allows the legislature to set the subject matter jurisdictions of the courts, and the subject matter jurisdiction statutes of the courts also allow for the legislature to restrict that jurisdiction. So what we come here is that the self-defense immunity of 215231 falls in that otherwise provided as law, as stated in KSA 20-301, giving the district courts its general jurisdiction. Now, we also got to note that as a jurisdictional matter, which comes from statute in the Constitution, this case doesn't turn on weird immunity analysis and weird, odd, esoteric immunity doctrines. It's straight up an issue of statutory interpretation. And because it's an issue of statutory interpretation, this is what also distinguishes this from other forms of immunity that are not jurisdictional, like qualified immunity, which is based on federal common law and therefore cannot be jurisdictional because it does not emanate from the Kansas Constitution and Kansas statutes. So when we move to the plain language of KSA 215231, we see that a person exercising lawful self-defense is immune from criminal prosecution and civil action stemming from the use of that force. Now, the criminal prosecution includes arrest, custody, charging, and essentially the entirety of the criminal process. As such, any charge that may have been filed prior to immunity finding, it can't control because it's not a valid charge at that point. Until those immunity findings have been had, the district court can't seize its jurisdiction to actually work on a charge that doesn't exist because a prosecutor is barred from charging until the immunity findings have been made.
Let me just ask you a question, and I know this whole thing is very confusing. But in Jones, in State v. Jones, a case from 2013, the defendant raised self-defense as a justification, but he didn't file a motion for immunity under 2232-19. But he did raise that defense as an immunity for the first time on appeal. And he actually analogized it to this stand your ground to qualified immunity, like you're talking about. And the Jones court didn't find the comparison a valid one, but it said there at least is one commonality. Both can be waived if not raised as an affirmative defense early in a case. Would you agree with that? That's
I don't, Your Honor, and I actually think that that statement kind of gets to the heart as to why this is so complicated. Because when we hear words immunity and we hear word self-defense, as lawyers who handle a lot of criminal cases, we attack these words with built-in assumptions, right? We hear self-defense, light goes off, oh, that's an affirmative defense, defendant bears the burden. If we actually look at the language of 52, of 215231, there's no requirement that the defendant brings the motion. There just is none. In fact, if the prosecution has to get these findings before they can charge and before they can arrest and detain and prosecute, there's nothing preventing the prosecution from also seeking these rulings. And I think that with these types of cases, this should be fairly clear from a mile away. You know, you have a use of force case, you go to prelim, prosecution say, hey, we have use of force, and we understand self-defense might be available. We're going to seek these findings now and put on your evidence. Because at the end of the day, regardless of when the defendant raises it, this is still the state's burden.
distinguish Jones.
I think Jones has been distinguished by Barlow. It was completely undercut where in Barlow, the defendant did not raise it at all, but the district court raised it sua sponte after jury trial.
But
And that was
even though,
affirmed.
okay, so even though Barlow says, the court may sua sponte consider stand your ground immunity at any time before sentencing, but nothing in Barlow appears to take away from the conclusion that defendant can waive.
But Mr. Jones did not waive when he raised it. So we're putting in a position, and I just want to,
But the holding of the case in Jones is that it can be waived if it's not raised as an affirmative defense.
but I would distinguish this with Mr. Jones's case because Mr. Jones did raise it. He filed a motion, they had a hearing, the district court made an abhorrent ruling on it, but he raised it. And where we're at in this position is we got to remember what immunity is. It's often thought of as an entitlement not to stand trial, but it also cuts off the remedy. And for people who are incarcerated, pre-trial, waiting for an outcome of the case, simply going to trial isn't an option. Mr. Jones got offered a plea for 13 months. He probably would have had to wait longer than that to attack his case via self-defense at trial. And even then, I would counsel a person, if I were a trial attorney, if I lose a self-defense motion that I think is incorrect, and I still get acquitted at trial, I am counseling that defendant. Yeah, I'm
Take your
kind
time.
of sick, tired, babies, you know, I'm just working on it. But if somebody goes to trial and is acquitted of the criminal charge, I am counseling that defendant to continue to litigate the motion for immunity, file a reconsideration, and appeal from there. Because even though you're acquitted at trial, that immunity determination is going to act as collateral estoppel in any sort of civil action.
Well,
Which can't
how
exist.
does that happen? I mean, isn't it your position here that, and I'm trying to procedurally understand this. Charges are filed, your client brings a motion to assert self-defense immunity. It is denied. And it seems to me that that point, you're saying the court is divested of jurisdiction to moving forward on anything. Is that your position?
If those findings are in error, yes. And I think that there's support in this in Phillips.
Well, you're always going to say it's an error if you're denied, right? I mean, so once it's denied, no further, the court is divested of jurisdiction to do anything further in the criminal case. What happened?
Yeah, and I understand. And I think that's a big problem with this immunity issue is because the statute doesn't really give a good procedural overlay of how this is supposed to work. And we can see this in these cases since 2012, the court's been struggling.
Well, you just gave an example where your client would have gone to trial and then afterwards, if he's acquitted, you would still appeal the ruling. So is that trial? They couldn't proceed with trial under your scenario.
Correct. And so one, if we went on the appeal, the conviction would go away, but he would also be immune from further civil prosecution for a wrongful death or for a battery or for the thing that he got criminally acquitted of. But unless you do that, once you're sued, they're just going to point back to the ruling that's already been made on immunity, and you're going to have to go through suit regardless as to whether that or not that was correct. But I also want to point out a couple of few things here. One, I want to bring this court's attention again. This is going to seem out left field, the State v. Sherman, prosecutorial error case. This court said, prosecutors, knock it off with the puzzle pieces. We're serious.
Knock it off with what?
Puzzle pieces, the voir dire analogy.
Right.
But this court also said, hey, we understand we hadn't given this ruling. Nobody knew about this. So we're going to find it harmless in this case, but issue this warning to these future cases. Now, when we talk about reviewing immunity determinations after they've been made, I think that there are three ways that immunity determinations can get reviewed. First off, I think after an adverse immunity finding, but before trial, like happened in McCracken v. Cole, a defendant could file a 1501 challenging their confinement as contrary to the laws and the Constitution. That happened once. I don't think that's necessarily the correct procedural path, especially when we're dealing with people who may not be in custody. But I think the actual correct procedural path is to an appeal and immunity judgment before trial under 60-2102A4. And that allows an appeal from a matter of right from the final decision in any action. Given that the immunity hearing is the gate to all the other subject matter jurisdiction, anybody should be able to appeal from that determination. And because the charge can't control until proper immunity determinations are fine, that is actually the proper appeal section rather than 223602, because until the immunity is properly found, it can't be a criminal case.
How does that argument align with Dunn? And it's holding that subject matter jurisdiction is essentially that you're in the right court for the type of case that is at issue, and we have territorial jurisdiction.
Territorial jurisdiction covered, but the self-defense statute 215231 operates that self-defense matters are subject matter jurisdiction that the court does not automatically have jurisdiction over unless the state or the plaintiff can make those showings.
So Dunn is incomplete?
I think Dunn is complete for the issue it dealt with charging documents. But I think when we deal with a statute that exempts out a specific level or a specific subject matter from normal jurisdiction.
I think
Yeah.
Dunn follows, frankly, in a long line of US Supreme Court cases, as well as some other cases that preceded Dunn in this court, where the courts have tried to clarify that sometimes the word jurisdiction is used more broadly than intended in past cases, and that jurisdiction really is what gets you into the door of the courtroom. And from there, what you're talking about are defenses or other types of things. And that seems in that context of courts, not just this court, but other courts really trying to narrow jurisdiction to just a very basic right to be in the court. With where immunity has to come, you're in court, and once you're in court, then the immunity issue is raised.
Oh, sorry.
I understand what you're talking about, but it does seem to expand on that, start to broaden that concept of jurisdiction once again.
And it might, but that was the decision the legislature made when they said that any person who uses force that's lawful is immune from, sorry, I probably should have highlighted this, is immune from criminal prosecution and civil action. And then when you define criminal prosecution to include the commencement of the actual charging, which is how you invoke the criminal subject matter jurisdiction of the court, until you make those findings, if you can't do that, then I think it is absolutely clear that 215231 is a subject matter jurisdiction dealing with the subject matter of self-defense. So that's why it's different and it's taken out, because it is a subject matter. The legislature did this, which is also why, as I mentioned in the supplemental brief, I think that out-of-state precedent, United States Supreme Court precedent are unhelpful here, because this is a Kansas specific provision. It comes from our statutes, our legislature, which we got to remember, our legislature loosened controlled carry or concealed carry much more broadly than anyone else in the nation. We redid our counterpart to the Second Amendment to be stronger. We pass this. I think that the legislature intends for self-defense to be jealously guarded and handled properly by the district court and taken care of to make sure that absolutely no valid self-defense case goes through, which is why I think once we separate the concepts of this immunity, which is jurisdictional, from everything else we know about affirmative defenses and who has to raise it, the statute's pretty clear that the state has to come over this hurdle before the district court can have any jurisdiction.
The hurdle you're creating is circular to me because possible that the court's judgment was correct. Your client's not entitled to immunity, in which case, to Justice Lukert's point, you have to stay in court. You have to keep going. But if the court was wrong, then everybody has to leave and walk out of the courtroom. There's no more action that can be done because you have a judge that's lost all his teeth.
And I understand, but I also think we need to look at the other side. If I win on this case, Mr. Jones has served an entire sentence that he's immune from. And so we need to get these decisions rendered. Yeah, Mr. Jones has served this entire sentence because he was offered 13 months. Had he went to trial, you're facing the trial tax because you're going to be charged with the much greater crimes that you're going to. You have to spend more time. And even then, you have to appeal. So therefore, there needs to be a mechanism to handle these jurisdiction things because what good is I understand he might be, but I also know that the district court said it was incumbent upon Mr. Jones to prove that he was immune beyond a reasonable doubt. So at any rate, when we go back to Phillips, the immunity does not impact the verdict because the immunity prevents a verdict from happening. So the same thing should be true with the plea.
Counsel, you're out of time, I know, and I just want real quick to get an answer to this question. For you to prevail, would we have to overrule our holding in State v. Smith?
No,
Why not?
because it was indisputable that there is jurisdiction in Smith to handle those crimes. They were just trying to figure out whether or not the Constitution was
Well,
complied with.
the holding of Smith
Mhm.
is that you can only take an appeal from a guilty plea or sentencing issues, or if, and I'm reading from the syllabus,
Mhm.
if the defendant files a motion in district court in accordance with the directives outlined in 60-1507. That didn't happen here, did it?
And I guess I do dispute Smith. That I do not think that
So
jurisdictional.
we
issue-
would have to overrule Smith.
You would have to overrule that aspect of Smith, but I think that aspect of Smith is completely wrong because we're shunting
Okay,
people.
that was my
Yeah,
question.
okay,
You
yeah.
think Smith's syllabus paragraph 1 is wrong?
Absolutely, because I think subject matter, I think that 223601A allows for people to raise the same issues on direct appeal or 1507. Now, you can't raise them both places, obviously, but I just don't see why we would shunt people into a 1507 to the same district court they had before without an attorney to make a finding, which I don't think this would probably be Smith simultaneously. So we're going up, back and up and down when it says as provided in. So I think you can raise all the 1507 claims in a direct appeal. You just have waived them for your 1507. I mean, it's kind of like going back for a Van Cleef hearing when there's no 1507. Well, I can't generally do that, but the reason why 1507 exists isn't because of the claims. It's because you got to get the evidence to raise those claims. And so if the evidence is there, then absolutely, I think that you can do that. And that paragraph of Smith should be reconsidered. And I am way out of time. I apologize. But I just request that this court reverse the Court of Appeals and either remand or take up the issue regarding the propriety of the district court's immunity hearing. Thank you.
Please the court, Andrew Davidson, on behalf of the state of Kansas. There's two Joneses. There's Mr. Deante Watley Jones, and then there's the Jones decision. So it's going to be a little difficult when I talk about people here, but in our case that we're here for today, Mr. Jones was seen by 4 completely neutral observers pull out a gun in the backseat of a car and pointed at a man who was yelling at the front seat occupants. The neutral observers stated that he did not approach or make any threats with any weapons or anything. Mr. Jones, in this case, shot him. Court made a ruling that pardon me. That did not meet the self-defense. We had a full hearing on that issue and he was found that he did not act in self-defense. There are two prongs on a self-defense, and the defendant has to show that he believed it was necessary to use force. And the second prong is that a reasonable person in that circumstances would have perceived the deadly force was necessary. We have, in this case, somebody who tried to exercise their right under that statute and failed. After that, approached the state for a plea offer, in which he was given a plea. He entered a plea of guilty and he acknowledged his wrongdoing at that time. As an affirmative defense that he brought and it failed, he saw the writing was on the wall and he entered a plea. Our Supreme Court has stated immunity, whether qualified or absolute, is an affirmative defense which must be affirmatively pleaded. And when he entered a plea of guilty, he abandoned that. And that's what this case is about. The Court of Appeals decision, I believe, was correct, that this isn't a jurisdictional issue. State v. Jones from 2013, the other Jones, cited all sorts of statutes that stated qualified immunity as an entitlement to not stand trial or face the burdens of litigation. And that's kind of what our self-defense law is about. It establishes that if you meet these qualifications, you don't have to stand trial. And in this
Counsel,
case, yes, yes, sir.
Just sorry to interrupt real quick. Following up on my last question to your opposing counsel, even if it is jurisdictional, even if the claim goes to jurisdiction as the defendant argues, we still wouldn't have appellate jurisdiction, would we? That's what I'm confused about.
I don't think, no, I don't think you do.
Doesn't Smith say we
Yes.
don't have jurisdiction?
And he's not satisfied those standards to get to this point. And he never filed a motion to withdraw his plea.
We're just procedurally, at least under existing law, where
Yes.
there's no procedural mechanism for this appeal.
I don't believe so. And I think that at this point,
Even if the immunity determination actually is jurisdictional.
I don't think it is
I
jurisdictional,
know,
but
but
even if it is,
were, we still would,
he's
under
way-
existing law, we would not have
I
jurisdiction.
believe that's correct.
Is there a way to appeal a denial of a self-defense immunity claim and enter a plea? Is there a way to preserve that question, absent some sort of declaration? That's what you're wanting to do.
I think-
Even in light of that, is there a way to do this?
I think defendants do this a lot in suppression type situations where you go, you have your suppression issue, the court denies it, and the defendant says, look, we don't want to go through a trial. How about a trial on stipulated facts? I'm not acknowledging my guilt. I'm not entering a guilty plea. We'll just submit the facts to the court and the court makes the decision. And I believe that is what would have preserved Mr. Watley Jones's.
But that would have to be, if he wanted to get the benefit of the plea, which is a reduced charge, and it would be a trial on stipulated facts to the agreed to plea or
Like an amended
something like
complaint?
that. I'm just trying to figure out a way that.
Maybe, but that didn't happen. In this case, the case was negotiated out to.
No, I understand.
Yes.
I'm just trying to understand if there's a way to preserve this absent your way.
People, defense attorneys and prosecutors get creative sometimes, and I imagine they could approach and say, how about you amend it to this chart? But then I don't know if you could do that way, but
I appreciate it didn't happen here.
I think,
Opposed to qualified immunity and other types of immunities, this does start by statute at the time of arrest, at the time of charging. Does that change how we have to view this? Because, I think the analogy to being the gate is maybe appropriate given the way the statute's worded. I'm not saying I necessarily agree that means jurisdiction's applied, but there are pre-trial things that would, that if determinations were made, would deprive the court or the prosecutor of even bringing the charge. Does that make a difference? And how?
Are you asking if this could be determined pre-charging?
I mean, if the prosecutor can't bring the charge, how does the court have jurisdiction?
I think the prosecutor has to bring a charge. I think they have to file a charge.
But does
They have to
that,
bring the,
but if the court nullifies that and says, no, wait, you did not have the right to bring this charge, then what does that ruling impact in terms of jurisdiction?
I think the court still has jurisdiction over the issue to decide. And I think a criminal case has to be filed in order to bring that in front of the court.
So you wouldn't wipe out jurisdiction which I think is maybe the practical implication of the defendant's position.
I would what?
What basically wipe it out and say, oh, well, if that's the ruling, we can't
the ru-
proceed further.
I think what happens is the court makes the ruling at the hearing for immunity and says, yeah, this defendant's immune from prosecution, and the case gets dismissed. I think that's how it works. I don't see a practical way to.
But you,
in-
I think what, perhaps if I'm reading it correct. What Chief Lukert is saying is that the court can't just go about ordering people about. There has to be a case filed.
Yes.
In order for us to have jurisdiction. Statute says that under certain circumstances, no case can be filed. Prosecutor has to leave him alone because he was acting in self-defense. So if the prosecutor can't file charges, then the court can't do anything about it, can they?
I think that you have to file a charge to get it in, get the controversy in front of the court to begin with. I think this court has decided this issue previously under State v. Jones in 2013. I think that there are other courts, even out of this jurisdiction, that have also stated the same, that this is an entitlement to not stand trial and not a jurisdictional issue. And that's what I'm asking this court to make a ruling on today. Are there any other questions? I will waive the rest of my time.
You reserve 3 minutes, Mr. Rand.
Thank you, Your Honor.
Counsel, if I understand the practical extension of your argument, it would be that every criminal defendant simply has to speak the word self-defense. And if the court says no, everything has to stop. Regardless of how frivolous the self-defense argument might be, because the court issued a ruling, all proceedings have to stop until that's somehow affirmed, right?
Not necessarily. So there are,
Jurisdictional, I don't see how my example doesn't work.
no, correct. So let's say, we go to trial, we have an immunity hearing, that's bad. You go to trial, you get convicted. You appeal, you still get the benefit of the immunity by getting out of prison, getting that conviction off. It just means that everything that happened was void. Now,
Why would the state, why would the court move? If the law was, if I'm wrong on how I rule, once the defendant spoke the word self-defense, why would you do anything until you had that nailed down?
because a couple of reasons. One, who's going to appeal it? If the state wants to appeal it and get it affirmed, if the defendant does not appeal, then the court has the jurisdiction unless this court later on direct appeal or further on goes. And now under the civil provision 602102, if the defendant appeals, then it comes up to this court, it's examined, and if there's no jurisdiction, it goes bad. With the court making the findings, it's taken the jurisdiction, it seized the jurisdiction, and whether that seizure was proper or not can always be litigated further.
How does the appellate court have any jurisdiction if
Because the district court, because the issue is the district court didn't have jurisdiction. And so essentially, if the district court doesn't have jurisdiction and a defendant can't appeal that, then I don't understand what the provision in a 1507 or 223602 allowing you to attack subject matter jurisdiction at any time. Because if there is no jurisdiction, you just got to sit in prison because you have no jurisdiction to get there, even though the jurisdiction that was improperly used has making you incarcerated.
Typically, we say that courts have a duty to examine their jurisdiction.
Absolutely.
Does this mean that all courts now have an affirmative duty to ask
I think they do.
immediately?
I think the courts have an affirmative duty to keep their eye out because again, this is self-defense. You can see these things coming from a mile away. You're not going to get a self-defense in a drug case. You're not going to get a self-defense in a theft. You know, we were only dealing with use of force. The prosecution also knows this facts. And like I said, the prosecution should be seeking these findings as well because the statute makes it incumbent that you can't charge until these findings are made. So again, nothing prevents the prosecution saying, hey, we're filing these charges. We're going to set a hearing for immunity. We're going to put on our evidence showing that there is no reasonable doubt, and you go on. Now, the finding of immunity of jurisdiction, a bad finding, is just kind of like any other bad trial finding. You can reverse it later, but everyone is operating off that assumption that it's correct until this court says otherwise. And I say I'm out of time, but can I just make one quick point about the underlying? I just wanted to point out that all of the uninterested observers did not say that Mr. Rodriguez was not attempting to get in the car. In fact, and it's Mr. Cayley at page 25, volume 7. What did you see? An argument between two people, two different vehicles, and one person in the vehicle got out and attempted to open the door of the other vehicle. He also told that to the officer on the scene, who testified that later at page 59 of volume 7. And then in the district court's ruling on page 34, volume 8, it's undisputed that Darren Rodriguez got out of the car that he was in with Paula Thomas and went over to the car driven by Devin Luna, and was aggressive. And what he was doing was not legally justified, pulling on the door handles and shouting things to people in the car. So to say that nobody saw anybody trying to pull on door handles is just completely wrong. But the district court also said that later in its ruling, which again, this ruling cannot confer that jurisdiction. And if this ruling can, then the statute's fairly meaningless. And so for this reason, I would just ask this court to recognize the plain language that stops the state from taking any action, as well as a civil plaintiff from taking any action until the immunity determination is dealt with.
I mean, the still puzzling me, but all the defendant has to do if they believe their self-defense claim is not plead guilty and take and wrestle it to the ground.
Wrestle it to
And
the
then
ground.
take it on in appeal.
And
There's no jurisdictional problem if you do that.
And I understand that, but the state also has no jurisdictional problem if they raise it correctly, if the findings are made. And we're putting this onus on the person who is incarcerated, who's facing the trial, who's facing the decision. Do you want to do extended pretrial incarceration? Do you want to take this great deal that's going to get me out? It's putting so much onus on the defendant to take care of something that the district court in the
You
state will
described
take care of
taking this
first.
great deal that gets me out. That happens every day in criminal courts where you accept a benefit of a negotiated plea and you're giving up something. That happens all the time. What's the difference here?
Because the only reason Mr. Jones was in that position is that the district court completely fouled up a decision that would have let him walk out the courthouse.
And there's a way to preserve that, even entering a plea, which is what Mr. Davidson described as a trial on stipulated facts or something like that, where you can at least preserve the question. You're not precluded from preserving the question, but by entering a plea, you're waiving all of those objections and that were previous to whatever occurred.
But I still think that is incorrect because you're entering into a plea to a court that doesn't have the jurisdiction to accept it. I understand that this is different, but if we read the statute, I don't see how anybody could plead to somebody on a decision that the state wasn't allowed to charge when the ruling is that bad. With that, I thank you. And I urge this court to adopt the plain language of the statute, find self-defense immunity jurisdictional, and reach the merits of the district court's immunity findings. Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement.